Good afternoon. Please be seated. This matter is the Associated Press versus the Washington State Legislature. Paul Lawrence will open for 15 minutes, reserving 5 minutes for rebuttal. Michelle Earl Hubbard will have 20 minutes for response. Counsel.
Thank you, Your Honor. May it please the Court, Paul Lawrence for the Washington State Legislature. This is a case purely of statutory interpretation. It raises two questions: whether the legislature and its members are state agencies as defined in the Public Records Act. The answer to that is no. And is the scope of the legislature's obligations under the Public Records Act limited to define legislative records to be administered by the Secretary of the Senate and the clerk?
Do you acknowledge that the legislators have ever been an agency, determined to be an agency?
I think that certainly originally when the definition included public official, they certainly would have been. I think it's a closer question during the period up until 2007, but clearly where we are now, given the amendments to the definition of agency in the Public Records Act and looking at what the legislature did with respect to the definition of agency in the Ethics Act and the Campaign Finance Act, the plain meaning is clear now that the legislature is not an agency.
So would you say 2007 was the clean break, so to speak?
Yes, that's when the specific definition was adopted for the Public Records Act that did not include specific definitions of state office that included the state legislature, which had been previously been in the Act. The trial court and the media made two fundamental errors in applying the plain meaning analysis. First, they refused to give weight to the amendments that we were just talking about. And this court has made clear that part of the plain meaning analysis includes the consideration of amendments to the Act.
Why didn't, if it was so plain, why didn't the legislature just say, this doesn't apply to us?
You're talking about the amendments in 2007? To me, it was plain that if they were saying that by not incorporating the definitions. If you look at the definitions in the Campaign Finance Act.
But clearly it's been confusing to people who've tried to construe what it means after the fact. And so I'm just wondering, you think that the clear intent, no, without getting to the intent, you think the clear language itself on its face should let everybody know that there's intended to be an exception for the legislature? First of all,
I don't think there's been any confusion on this. There's no history that, actually since 1995, that the legislature has accepted that it is covered by the Public Records Act. If you look at the declaration of Jeannie Gurel, she testifies that the practice from 1995 has been consistent and attached to House rules. So I'm not sure there's confusion. But I think in trying to understand what the plain meaning is, you look at the text, you look at the amendments, and it's hard to imagine something clearer than when you say, okay, you take away the definition that included legislative offices, you take the definition, away the definition that included the offices of the legislature, et cetera, and put those only in the Campaign and Ethics Act. And it's as clear as it is with respect to the judiciary. The holding in the case that held the judiciary was not subject to the Public Records Act made the point, look, it didn't say judiciary in the definition of agency. Well, it doesn't say state legislature in the definition of agency either.
You think it's the same analysis and not the separation of powers or the constitutional arguments you say aren't in this case that leads to that conclusion?
Well, there's the analysis that was done with respect to the judiciary was a multiple-part analysis that first started with the text of the statute. It then looked to whether or not, for example, the Constitution allowed the judiciary to set its own rules, and the court looked at that. And in this case, the Constitution allows the state legislature to set its own rules. The court also looked at whether or not the Constitution had some requirements for record keeping for the judiciary. And similarly here, the Constitution requires certain legislative records be kept open and available to the public. So the analysis is really on all fours with the analysis that was done of the judiciary, in which this court found the judiciary.
Wouldn't it have been simpler for this court to say in one of those cases in Naster and Koenig that the Public Records Act applies only to executive branch entities? Because that's essentially the end result of your argument.
Well, yes, if that issue had been addressed directly to the court, but I don't think that question has been addressed directly to the court. I will just note that we don't take the position that there's no aspect of the Public Records Act that applies to the state legislature. The state legislature, in its own right to determine what goes in and out of that, has said that there are certain legislative records that are defined as public records under the Act, and that those have to be made available.
But what's odd about that to me, and maybe this is part of the way the case was divided at the trial court, is that's a definition of what is a record. But you start with the definition of who is an agency. And I don't know why we'd even get to what's a record if we don't even have an agency. And yet it's odd that the statute would include records of entities you're saying are not even an agency.
Well, I don't think that there's anything odd about a choice that the legislature has the constitutional authority to make to decide how its records and which of its records are public and subject to disclosure under the Public Records Act. I think that is certainly within its authority to do. And although you find that not in the definition of agency, you find it in the definition of public records. There's also several references in the Public Records Act that define the duties of the Secretary of the Senate and the Clerk of the House that are very similar to the type of duties that are assigned to
But I guess that's
agencies.
what I'm getting at, is doesn't that suggest then that the legislature didn't think that its definition of agency excluded legislative entities because it has specific provisions speaking to their records?
I would disagree with that. I think the legislature was trying to define what records of its would be subject to the public and disclosure and how it would be defined. I don't think that there's any case law. If you look at the Constitution doesn't talk about the legislature in terms of an agency. It is its own branch of government the same way the judiciary is. The legislature, the cases defining the legislator's power under the Constitution don't ever talk about it as an agency. The legislature creates agencies. That's certainly true, but agencies don't have the power to create laws. So this court's jurisprudence about what the legislature is has made that distinction between the legislature as a branch of government and the status of agencies, which are things that are created by the legislature. So I think in terms of the text, which Justice Stevens has been talking about, that supports the idea that the state legislature is not included, particularly in light of the language used, but also particularly in light of the amendments to the provisions of the Public Records Act, which this court has recognized as recently as the Columbia Riverkeeper case and the State versus Evergreen Freedom Foundation case, has to be considered as part of the plain meaning analysis. It is significant that the trial court seemed to want to ignore that point. The trial court made a point of saying, I don't see how amendments apply to my interpretation of the Act. Well, it's very clear that this court has said amendments do apply to the plain meaning analysis. And there's never been any explanation as to how you get from a situation where you have a definition that arguably specifically includes the state legislature, and then that definition is changed so it doesn't. And as this court has said several times, applying regular canons of statutory construction, that when there is a change in language of a statute by the legislator, it is presumed to have meaning. So you should presume that that change that occurred has meaning when the legislature decided not to incorporate a definition that made clear that the legislature and its members are included within the definition of agency.
So, counsel, you said earlier that the legislature is not or has not traditionally been described as an agency, but in the original definition that was shared by the CDC and the PRA, they were.
And maybe I missed, but what I was saying that it has not been in terms of the case law, in terms of how either the Constitution or this court has, outside of the PRA context, defined the legislature as an agency. I think it is certainly within the power of the legislature and the people acting as a legislature, with potential exceptions, which are not really at issue in this case about legislative privilege, has the authority to provide some of those records or a majority of records as public records. And I think, as we said, when public official was part of the Public Records Act as well as the broader thing, it's really not an argument that public official would include the state legislative office holders, though arguably it should also have included the state Supreme Court since we all vote for you and you're a public official. But putting aside that, what I was talking about is the case law and the Constitution is how it describes what the legislature is, distinct from what a state agency is.
And so you're saying that there was a policy choice made by the legislature to say, municipality, county, you have to comply, but we don't. There's some distinction between them and us, whatever that is, and that's a choice made by the legislature.
That is correct. I think that choice is reflected if you even look at the definitions of state agency and local agency in the Public Records Act. The local agency includes every city, county, town, municipal corporation. That type of language is not found under state agency. And although we recognize that some local entities do have part-time legislative bodies, the state legislature is particularly challenged being a part-time legislature and the intensity that goes on during the legislative session. So it was a legitimate policy choice to say the Public Records Act applies only in the more limited way to the state legislature.
I find it puzzling that there wasn't as much a notice to the public, or there, I don't recall, I was a regular newspaper reader back then, and I don't recall seeing anything in the paper saying the legislature exempted themselves from being subject to the Public Records Act. Did somebody just not pick up on it, or is it in the legislative history somewhere?
Maybe you should ask the media that's over there.
I will.
But you know, clearly the changes in the law were publicly made and discussed, so it wasn't something that was hidden, it wasn't something that was done at midnight that nobody could see coming. So why it wasn't covered that way, I think in part because there had been no history of the legislature responding to the Public Records Act.
Is it actually an exemption?
No, it's not an exemption because A, the legislature is not an agency, and B, the legislature has, to the extent that the records are coming in through the notion of the Secretary of the Senate and the Clerk of the House, those seem to be records that would be subject to an exemption. So the original part is not an exemption, but to the extent the records have been made available through the Public Records Act, they would be subject to
But given that your argument is that the only way legislative records come into the PRA is under that definition of public record, where does that leave the exemption sections of the PRA? Because they tend to speak to agency. So ongoing employment investigation, an agency need not disclose, but you're not an agency.
So I would say, again, if you look, there are other provisions of the Public Records Act that talked about the rules and procedures, et cetera, that the Secretary and the Clerk must make. I'd also point out that none of the exemptions are at issue in this lawsuit, and that there certainly would be, putting aside the exemptions, as we know, there are common law privacy rights that might be implicated by records regardless of the exemption. And so
I'm asking this, though, really as a question of just textual interpretation, because the Act is written in terms of agencies' obligations. But if you're saying the legislature has some obligation because of the definition of public record, but it isn't an agency, why would those other provisions apply to the legislature at all?
Well, I don't think that issue is before you. It makes common sense that given the way that the Public Records Act treats the Secretary of the Senate and the Clerk of the House and their responsibilities and puts obligations on them that are similar to the obligations on agencies, including rules and procedures and copying and all that things, it would strike me as...
You're saying in the PRA, or are you talking about the record retention statute?
In the Public Records Act, in addition to the definition of public records, there are other provisions which we point to in our briefing, and I'm sorry I can't cite them to you right now, that talk about require the Secretary and the Clerk of the House to adopt rules and procedures, which they did, to address public records requests. So there are other things that are in the Public Records Act that set forth the obligations of the Secretary and Clerk.
Don't the obligations of the Clerk and the Secretary include disclosure of some of the records that Justice Stevens was talking about? Because my understanding is that the Clerk and the Secretary maintain not just records of legislative committees, but they're also responsible for hiring, retention, and firing of all personnel in the Senate, and that they would be the storehouse of those records? Right, which I believe it might have been what she was asking about.
Again, I'm sorry if I missed that, but you're right. There are two categories of records under the definition of legislative records. One is the adoption of what's in the Constitution as required, but then the legislature has expanded the definition of legislative records to include, for example, personnel, information about the economics of personnel leave, et cetera.
And wouldn't that give information about individual legislators anyway, because the employees of individual legislators are, you know, technically hired by the clerk or the secretary?
I don't believe the specifics that were asked here would fall into that, nor has that argument been made. So I can't say that we fully addressed that in briefing since it was not an argument made. In answering your question, I feel I've used all my time. If there's any gratitude for additional time, it will be taken. Otherwise, we would ask that you affirm the trial court except with respect to its decision as to individual legislators. Thank you.
Lawrence, Mr. Earl Hubbard.
Thank you, Your Honor. I don't think it can realistically be disputed that the people, when they acted as legislatures and enacted an Initiative 276, intended that act to apply to all facets of government. What instead has been argued to you is that at some point the legislature amended that interpretation of agency to somehow remove that branch of government, the subparts of the legislature and the individual legislators. And as was correctly asked, is at what point did that occur? And what was the notice to the public that that was what you were doing? Your job in interpreting the statute is to look at the words that are actually written, to decide whether or not those words are ambiguous, and if they are, then to look at legislative history. But I will first point out that you do not need to decide that this is an ambiguous statute, because you look at the words with the definitions that have been given, and when there are no definitions given, you give them their common dictionary definitions. The definition of agency in Initiative 276 and today is very broad. The dictionary definitions of each of those terms is equally very clear, very common, and very broad. And as the trial court recognized, those subparts of state agency, which the legislature has not seen fit to define in the current version of the PRA, appropriately could be seen as applying to the legislature, the Senate, the House, and all of its subparts.
Well, do we look at what happened in 2007? Your rendition of what the people enacted might certainly be completely accurate, but that's not what's on the books now. Well, what we're supposed to interpret is what's on the books now.
Yes.
And I see that since 2007, the legislature actually changed the definition.
Well, they didn't change the definition, Your Honor. What they actually did with respect is in 1977, when they took out the word public official.
2007?
In 1990, sorry, 1777, I'm going way back. 1777, for 5 years, they gave us what we actually passed, and it had public officials as an agency.
I don't think you mean 1777.
Oh, did I say 17? Sorry, 1977, you're right. They took out the word public official. But if you look at what they said when they did that, it made very clear that that was to make it explicit that it applied to all levels of government. Nothing in that was that telling the public that by removing the word public official, they were taking out branches of government.
Let's talk about 2007.
In 2007, what they did, in 2005, they said, look back to the definition we've had for the last 12 years, since 1995, which specifically has state office as state legislative office. No one is disputing that. They seem to be conceding now that individuals were agencies from 1995 at least up until 2005 or 2007.
Because of the cross-reference. But the cross-reference was deleted in 2007.
They didn't delete it. They just didn't, Your Honor, they just didn't carry it forward. So what they did in 2007 is they said, we're not going to cross-reference, we're going to do our own definitions. Here's 4. Agency, writing, public record. That's it. They did not give us a definition of state office. They did not give us a definition.
Is it your argument that in 2007, the legislature did not delete that definition and put it in an entirely separate statute, the Fair Campaign Practices Act?
They did not delete anything, Your Honor. What they did when they divided the PRA in 2005 They put provisions in the PRA, which they were very clear was to help the public find things.
And they cross-referenced
and said, and all the definitions are back where they've always been, back in 4217.
But then they took out the cross-reference in 2007.
No, and then in 2017, in a cleanup bill, they carried over their own little definition, but they only defined the 3 umbrella terms. They never gave us subdivisions. If you don't define the term state office, you have never defined the word division, department, commission, you then are left with looking to the dictionary definition or the definition it had had for the past 12 years in a related statute. So my point is, not once did they say, by the way, by doing this, we're now exempting an entire branch of government. They also didn't give you anything in its place. And by not giving you anything in its place, you are necessarily to apply the common definition it had had for the past 12 years.
So do you acknowledge that we are not to apply the no longer cross-referenced definition from the Fair Campaign Practices Act? We simply go to dictionaries now?
Well, you are to apply state office because it was the definition it had commonly had. It wasn't the Campaign Finance Act. It was the Public Disclosure Act, which was all of it. And it was a single definitional section. Every single provision alphabetically was listed in that same section. There was absolutely no distinguishing.
I'm not sure you're really answering my question.
I'm trying to, Your Honor. What I'm trying to say is the state office definition, because they didn't see fit to give us a new one, then, like the trial court did, you look back to the definition it had had in this joint law for all of those years, and for all the other terms, you use the common dictionary definition as you should. One thing I'd like to point out, because there seems to be this argument that agency has some mystical meaning, it's secret, or it's only executive agencies. I have pointed out in our opening brief all the times in the state of Washington where our governmental entities list as an agency the legislature, the Senate, and the House. It's just a common term that is applied to a division of government. I've given you a federal statute that shows that agency is a division of government, which is what we have across the street. This argument that somehow it cannot apply to the defendants here in this case has never been supported by anything except this revisionist history as to what they did. One thing I'd like you to realize is that when they did seek to exempt themselves, they did so explicitly. In 2003 and 2005, they realized that individual legislators had a duty to produce records, and individual legislators tried to change that, and those amendments did not become law. In 2018, they did pass a law exempting themselves, and there was a huge public outcry. The governor vetoed it, and the veto was not overwritten. This year, in 2019, they again explicitly sought to exempt themselves, and that bill did not become law. So when they mean to remove themselves from the public accountability that the people intended in 1972, they tell us that's what they're doing. And when they do that, the people, as the original legislators, react and tell them that was not their will, and to go back to the law the way it was intended.
So can I ask you another method of interpretation is to look at legislative acquiescence in court decisions. And this court, over the span of many years, exempted judicial branch, administrative records. Under your broad notion of agency, certainly the judicial branch is a division of state government. But what about the interpretation there as being something the legislature was also presumably aware of, certainly NAST?
Well, so first of all, Your Honor, in NAST it was about court case records, and as you correctly pointed out in your dissent in the Koenig case, 2 months after the Morgan case, where the very investigative records and emails had already been ruled by this court to be produced under the PRA, you held that NAST hadn't actually really needed to say what it said, and you dissented. I understand that when I stood before you roughly 8 years ago in the Yakima case, you did not go our way. You gave us another way to get records, again, not overruling yourselves in NAST and in Koenig. However, the important thing is for this particular legislative body, for these particular officials, the legislature has used words that you found lacking in terms of the judiciary, where we had legislative office defined as state office, and we had language in the 1972 provision specifically talking about all facets of government, governmental decision-making, our elected leaders, things that were much different than the role that is played by the judiciary. So I know that the drum that has been beating is, gee, if you rule for us on the legislature, then you're risking opening up the judiciary. And while I disagree with the rulings that were made as to the 3 cases, I've given you in our latest amici response an explanation how I think you could have gotten there and did, because in each of those cases, there was a constitutional right of access that was far superior to the PRA. There was another means of getting each and every one of the records that was at issue. And so to say that the judiciary wasn't mentioned, to say that the branch may not have applied, again, 8-10 years ago now, in some cases, well, I think it was wrong. I don't think you necessarily have to revisit it because, first of all, that case is not before you. Were it become before you another day, who knows what you would say. Counsel. But I do think as to the legislature, you have to apply the law as written. And as to the individuals, they did use the word legislative offices, something we do not see anywhere in the definition section. Yes, Your Honor.
Opposing counsel started by saying this is purely a statutory interpretation question before us today. Do you agree with that analysis or that characterization of what we're doing here?
Well, to decide, both parties agree that the records, if they exist, and if these defendants are subject to the Act, are public records. Both sides agree that if these entities are subject to the Act, then they would have violated the Act because they told us you can't have any records and they didn't give us adequate explanations. So in terms of whether or not they have committed a violation, that comes down to statutory construction in terms of, are they an agency? Are the records we sought covered by the PRA? So yes, in that respect, I do. But in terms of everything else, the constitutional separation of powers argument, I don't think is really been fleshed out. And I guess the only basis of that is they're trying to argue that by putting in the definition that they claim they took out, that somehow you would be stepping into their shoes. All we're saying is the statutory interpretation, which is your job, is to determine what the words mean. And since they haven't told you what they mean, you have to come up with a meaning. And that their arguments that somehow the people or the legislature never meant it to apply to them are not supported by the language or by the last 45 years of history.
So yes.
So the answer, I think, is yes, if I'm following. And the other thing I would point out in answer to the question about court records is in the Yakima case, you rejected my argument that we would leave records in a black hole if we exempted the judiciary. Because in that case, yes, you pointed out there were other ways the public would get it. In this case, we truly would be falling into the black hole.
Well, can I stop you on that? Because sure. I'm looking at the definition of public records, and it definitely refers to other places where records are retained, bills, maybe archived somewhere else. The state library may archive something else. One could say there's some parallel there, that we're talking here about records housed or retained by, under the statute addressing the chief clerk or the secretary of the Senate, that wouldn't otherwise be the types that are then kept by the Secretary of State or the library. It doesn't sound like a black hole.
No, because we're talking about different records. The definition for the secretary and the clerk's records, first of all, it's not an exclusive list. What it says is, it is the legislative records under 4004, I believe it is, and also this laundry list of things, which those two staff offices are obligated to compile and produce. And there was, to prevent this crossover where you could go to the Secretary of State for it, then go to the Secretary of State for it, don't go to the clerk and the secretary. What I'm talking about are the workplace harassment complaints and whatever the agency, whatever the legislature did in response, the emails, the text messages, the calendars of the individual defendants we've asked for. There is no way to get those
Can I ask
if you
this too, because
find
I was
the
looking
PRA
at
doesn't apply.
excuse me, I'm sorry. I was looking at the provisions of Chapter 4014. Am I correct in understanding that even as to active matters in the legislature, the material doesn't go to the secretary or the clerk until so many days after signee dies? So if there were a request for records relating to active
I believe that is true, but the part of the problem is that they control the role of the clerk and the secretary, their staff. And they can change those rules at any time, and they can change procedures at any time. So yes, I do think there is, again, a window of things where even the things that are documented wouldn't necessarily be in those individuals' hands. But what I'm talking about are the records that are of utmost public importance, which you recognized in Bellevue John Doe's versus Bellevue School District, for example, and in Bainbridge Island Police Guild versus City of Puyallup, misconduct and harassment complaints and investigations, and recognize the public interest in the public not just knowing the outcome of such investigations, but what they were investigating and what they did to reach a conclusion whether or not something was unsubstantiated. Those records would never be able to see the light of day as to this entire branch of government if you find that this entity and the individual elected officials are somehow left out of this law. And the law itself does not support that. There is no other vehicle, unlike the 3 court cases, where you pointed out another way that the public could get the records that they so desperately needed. The emails and the text messages, which you found in O'Neill versus Shoreline and in Nissen versus Pierce County, that public officials had to produce, including a city council elected legislative person. Under the PRA, they couldn't get those same text messages, those same email messages from elected legislators if you found they weren't subject. And the workplace harassment complaint that you found in City of Federal Way versus Morgan, that you ordered to be produced in that case 2 months before the Koenig case, and the email to the city attorney and the city council member that you ordered to be produced under the PRA, those would not be accessible if we were dealing with legislative records or legislators. So my point is to all of this is that the people were the first legislators. It is their will and their intent that should be honored. And at no time have our elected legislators ever openly and successfully exempted themselves and those bodies from the reach of the term agency. And on the 4 occasions that they tried, all of them failed.
Can I ask you to comment on 4014-100, which defines legislative records, and it defines legislative records as certain things, but it goes on to say, but does not include the records of blah, 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 or reports or correspondence made or received by or in any way under the personal control of the individual members of the legislature. I'm just reading what the legislature enacted.
Because, Your Honor, in the 1995 amendment in the PRA, the 4217 version of that, what they said was public records as to the clerk and the secretary mean that definition and all these following things, and don't include the records of the individuals. And in that very same bill, defined the term state office to mean state legislative office, to mean the office of every senator and every representative. So as we pointed out in our briefing, through a witness, by the way, with far more history, foundational, personal observation than the individual that they offered as their intent knowledge, was to have the individuals produce all the stuff that the secretary and clerk couldn't make them produce, their individual correspondence, their individual emails. They put the onus on them by defining them as state agencies because the staff couldn't make their boss give them the records otherwise, and then said, what you get from the clerk and the secretary does not include those things. Why? Because it was to prevent all of my clients from going to the clerk and the secretary and saying, give me Senator so-and-so's emails, when instead you were going to go to Senator so-and-so. Now, Senator so-and-so could totally decide to have the clerk and the secretary administer that function and produce those records. That would be fine. But the secretary and clerk couldn't compel the senator to give those records to them. And that's why they broke out that workplace responsibility. It wasn't at all to change the definition of agency, nor does it say it did. It only defined definition of public records slightly differently.
Could I ask you, you referred in a previous answer to the legislature exempting themselves. Are you looking at this as an exemption, or are you just using that as
I'm using it as a poor word, yeah, as a bad word, to say that it does not apply to them, that this law that has been passed by the people cannot apply to them. It is an entirely valid point to say that they define the word agency in a certain way, and there are exemptions to the PRA which specifically apply only to agencies and only to agencies' records. And so one of their arguments that the clerk and the secretary are not agencies means that those two staff offices cannot avail themselves of all of these exemptions for records that are within the things that those two offices are tasked to produce, including various types of personnel records, which again goes to show that the intent of the statute was never to make these entities not subject as agencies under the PRA. It was just a way of defining the scope of the records that those two staff offices would be producing. My light's gone on. Does that mean it's a slightly different system? So,
yes, thank you.
Okay, thank you very much.
Lawrence, you have 4 minutes and 44 seconds.
Okay, thank you, Your Honor. Used all my time. But, so a couple of points. First of all, we're not arguing that this is an ambiguous statute. We're arguing that the plain meaning analysis applies, and the plain meaning analysis includes the consideration of amendments to the statute. We heard that there are all these other parts of, I guess, websites that include the legislature as a state agency for accounting purposes. I will also note that those same websites include the Supreme Court and the Court of Appeals as agencies for accounting purposes, so I don't think that proves anywhere. I think the most important thing to consider, which a lot of the discussion has been about, is how specific the Public Records Act has been or not been with respect to the state legislative office. Contrary to what was just said, the original Public Records Act did not specifically talk about state legislative office. That was added in 1995, where for the first time a definition of state office was added by the legislature to the Public Records Act in the context of defining state office to mean the state legislative office.
But does that suggest that when the campaign disclosure and the PRA were combined, I mean, clearly legislators were contemplated?
I agree with your interpretation that the purpose of including state office was most likely simply to make clear that the campaign finance and ethics law applied. And in fact, if you look at the revisions made in 1995, the only place where state office is mentioned is with respect to campaign finance and ethics. But to the extent there was any question that it was to apply more broadly, it came out in 2007 and simply remained with the campaign finance and with the ethics law. And I think the state AG kind of almost gives this point significant validity. In their brief, they talk about how from 1995 to 2007 it was explicit, that means it was in the text, that state legislative offices was an agency. But from 2007 it was, quote, implicit only. I don't believe there's any case law in this state that suggests that going from explicit to implicit should mean that what was there before is the same as what was there after. And in fact, that is absolutely contrary to all rules of statutory construction, which this court has applied again and again, which said when the legislature makes a change, we have to presume it means something. When words are used and then changed, it have to presume it means something. The legislature does not make these decisions in a vacuum, and we do not ignore the decisions that they made.
Well, it would be more persuasive if they gave some meaning to the word agency when they made the 2007 amendments. But given that they didn't, don't we look at what it meant at some time? Why would we resort to a dictionary definition as opposed to looking at statutes that are so intimately related?
Well, it's not entirely clear. I mean, if you go through the history, it's not entirely clear. It did include public official as as originally defined by the initiative. Public official was then taken out. State office was then put back in 1995 and then taken out in 2007. So I'm not really sure how far you can go with trying to understand other than what at particular point of time the issue is raised. And here, the issue is raised post-2007 and with the definition of agency. And as we've argued, that the common understanding of the term agency, outside of the PROA, the way this court has looked at agency versus the legislature, they are distinct entities. So applying either a common definition or applying how this court or the Constitution treats the legislature as opposed to state agencies, that they are distinct entities.
So can I make sure I understand your argument in terms of how it plays out? Because I read you as limiting that distinction to the state level, not the local level. I don't hear you saying that local legislators, city council, county council are exempt.
That is correct.
Or not covered. I guess we're all using exempt a little loosely.
Yeah, I understand. But so first of all, the state office definition was the only thing that talked about state legislative office. And as I said, there's a distinction in the current Public Record Act definition of agency that the local agency is defined much more broadly than a state agency. So I think the local agency covers the government entities, the county commissioners, et cetera, the city
Can you tell me which word? Because it also says office, department, division, bureau, board, commission at the local level. It repeats the same word.
Not necessarily. Look, it says it includes every county, city, town, municipal corporation, quasi-municipal corporation, or special purpose district, or any office, department, division, bureau, board, commission, or agency thereof. So the text distinguishes between office of those things and agencies of those things, and that distinction is certainly quite different than the way that the state agency definition is written. Thank you, Your Honor.
Mr. Lawrence, the court will be in recess, or will be adjourned.